Good morning, this is Risa. Hello there. I'm going to be reading this book, 2020 California Real Estate Exam Prep Questions and Answers. And the directions are to read the question. These are sample questions, and then read the correct answer, then read the explanation. So here we go. An executory contract is a contract that is yet to be performed by one or both parties. An executory contract is one that is to be performed as distinct from an executed contract which has been fully performed. Mr. Applegate purchased a home in a subdivision through broker Abel. Applegate applied for a loan, and on the loan application, there were 2 boxes that he was asked to check. One box was for marital status, and the other for race. Applegate may refuse to answer the questions on race and marital status. The applicant may refuse to answer about race since the information is optional on the typical real estate loan application. Both federal and California law prohibit discrimination on the basis of marital status. Therefore, a marital status cannot be considered by the lender to be a material fact. The borrower may then refuse to answer the question. Okay, I'm trying to read this as best I can. The landlord and tenant mutually agree to terminate a lease. This is often referred to as surrender. Surrender is a mutual agreement between the landlord and tenant to terminate a lease. Rescission is a mutual agreement to release each other from any contract before performance, under which the parties must restore each other to their former positions. Number 4. Under the Truth in Lending Act, a notice of cancellation could be given that the loan was secured by the owner's residence. The Federal Truth in Lending Act requires a notice of right to rescind only when security for the loan is the borrower's existing principal residence. Number 5. What would create an interest in property with possessory rights but no form of title? It would be a sublease. A sublease is a transfer of less than the leasehold with the reversion in the sublessor and would create no form of title in the sublessee. A land contract transfers 1. Possession, 2. Equitable title, and 3. The right to acquire the fee title after all the conditions of the contract have been met. A mortgage does not convey any possessory interest. It is a security device. Number 6. An appraiser received a $300 fee from Jones for appraising Brown's property. The appraiser may discuss the details of the appraisal with Jones. The appraiser should preserve a professional, confidential relationship with his or her client and should report the conclusions and valuation concerning the property only to the client. Although Brown owns the property, Brown is not entitled to information paid for by Jones. Lenders do have an obligation by law to provide a copy of the appraisal to a borrower under specific circumstances. Number 6. In the planning and engineering of a tract for subdivision purposes, a cul-de-sac is frequently employed. This term is in reference to the installation of streets. Cul-de-sac refers to a dead-end street. A broker who is not authorized to accept deposits in his listing agreement must inform the offerer that the risk of loss lies solely with the buyer. The seller will not be liable in event of loss of the deposit. Explanation: an agent who accepts a deposit from a buyer, even though not authorized by the seller to do so, acts as an agent of the buyer as to the handling of that deposit. Since the seller would not be liable in the event of loss of the deposit, the buyer should be so informed. Oops. Okay. Number 9, a clause in a second trust deed that permits the first trust deed to be refinanced without affecting its priority would be known as, it says the answer is none of these, so the answer is a subordination clause is a clause that allows for such a change in lien priority. When an existing contract is replaced by an entirely new contract, this is an act of novation. The word novation comes from the Latin words making new. Number 11. The distinguishing characteristic of real property as opposed to personal property is that real property is immovable. Real property consists of that which is immovable by law. Number 12. All of these people can sue for specific performance except a broker acting as the agent for the principal. A broker acting as an agent would not likely be able to sue his principal for specific performance because the broker is not a party to his principal's contract. And then number 13. An agreement with a lender that prohibits early payoff of a loan is known as a lock-in clause. A lock-in clause is a clause that may appear in a note or land contract that prohibits the lendee from paying off the indebtedness before the date set forth in the contract. Number 14. The quickness with which assets can be converted into cash is known as liquidity. Liquidity is the ability to convert assets into cash at a price close to true value. Stocks that are traded publicly are a relatively liquid investment. Real estate is considered to be a longer-term investment and is not highly liquid. Number 15. A licensee can legally do all of these things except fail to use a termination date on an exclusive listing. Using an exclusive listing without a definite termination date is a violation of the real estate law. So always use a date. Number 16. Lessee may be justified in abandoning a rented dwelling if there is a constructive eviction by the landlord. All of these would be constructive eviction except failure of the landlord to repair excessive wear and tear to property caused by the tenant. A landlord would not be likely to be found guilty of constructive eviction for failing to repair excessive wear and tear caused by the tenant. The 3 other circumstances would be classified as constructive eviction, which I think I'm going to read the other ones. So these would be constructive eviction. An eviction notice is tendered by the landlord. That's one of them. Another is unwarranted delays by the landlord after notice to make repairs of damages that have been made to the property unfit for occupancy. And C, condemnation of the entire property in eminent domain proceedings. Okay, number 17. A landlord would not likely be found guilty of constructive eviction for failing to repair excessive wear and tear. Oops, I accidentally started reading that one. Okay, I'm going to go to number 17. An investor purchased an apartment building with a very small down payment. and was able to secure financing for the balance. A year later, he sold the property for profit with no increase in his investment. This is an example of leverage. I want to read that again. An investor purchased an apartment building with a very small down payment and was able to secure financing. I think it's secure financing is like the point of leverage for the balance. A year later, he sold the property for profit with no increase in his investment. This is an example of leverage. Explanation. His basic idea of leverage is to use other people's money to finance purchases to realize greater return on your investment. The increase is called appreciation. Number 18. Franklin offered to perform all of the obligations in a purchase contract. The act is considered a tender. Tender is the act by which one offers to perform under a contract. It is not the actual performance. Okay, number 19. An escrow company received 2 termite reports in which the estimates of cost of the work differed. Under these circumstances, the seller and broker should present both reports to the buyer. Explanation. The results of a pest control inspection report, including the cost of corrective work, would be material facts to a buyer and must be disclosed. If 2 or more inspections are made, all reports must be disclosed. Number 20. A contract signed under duress would be voidable when the mutual consent to a contract is induced by fraud, duress, menace, or undue influence. The contract is voidable at the option of the wronged party. Number 21. A listing agent gave part of his commission to the buyer. He must disclose this to the seller. That an agent gave part of his commission to the buyer would be considered a material fact. The fiduciary relationship of the agent to the principal requires full disclosure of all material facts. The agent would not be disciplined by the real estate commissioner unless the broker failed to disclose his material fact to the principal. So it's material fact to give part of your commission to the buyer. Alright. Amenities of residential real estate are measurable on the market. Amenities are the attractive or desirable features of a home or neighborhood. They may be physical attributes or perhaps the neighborhood's attitude towards schools, well-kept lawns, etc. These may be tangible or intangible qualities measurable on the market. Number 23. Mr. Ferguson purchased a property for $125,000 with 12% cash down. He refinanced the balance with equal monthly payments of $1,048, which included 11% interest, and the loan would be fully amortized in 30 years. Mr. Ferguson sold the property for $139,750 before making any payments on the loan. What was his equity at the time of sale? And the answer is $29,750. The explanation is The purchase price is $125,000. Equity at purchase. Less down payment is $15,000. In parentheses, 0.12 cents. Oh, 0.12. It says 0.12, not cents. 0.12 cash down times $125,000. The loan is $110,000. The selling price is $139,750, and minus the less loan, which is negative $110,000, and so that means the equity would be $29,750 at the time of sale. Okay, number 24. Which loan costs are not required to be disclosed as a finance charge to the customer under federal truth in lending rules? I want to read that one again. Which loan costs are not required to be disclosed as a finance charge to the customer under the federal truth in lending rules? Credit investigation. Under the Truth in Lending Act, buyers' points, time price differential, and finder's fees must be disclosed to the in the finance charge. Exempted charges on residential mortgage transactions include title insurance, document cost, recording and notary fees, credit investigations, and appraisal fees. Number 25. A seller sued a real estate broker. I'm just adjusting. A seller sued a real estate broker for misrepresentation of a material fact that the broker had made to him during the sale transaction. In defending the suit, the broker was able to prove that the listing contract with the seller had been an oral agreement. Under these circumstances, this defense is not a bar because it was not the issue. The broker cannot use the statute of frauds as a defense in this situation. The statute requires that the listing contract be in writing to be enforceable in court, but has nothing to do with misrepresentation. Which document is not a means of creating an interest in real property? Bill of sale. A bill of sale is used to convey title to personal property, not real property. Number 27. A broker who is selling property on which he holds an option must inform the buyer that he is a principal. A broker who holds an option to purchase real property is a principal. He is not representing a seller, but is dealing on his own behalf, a fact that must be disclosed to a purchaser. Number 28. Which would have the least effect on property taxes in a community? Homestead exemptions. Homesteads will not protect the owners from property taxes and would have the least effect on them. Number 29. A lease for a period of years that is held by the lessor is an example of personal property. While in fact the lessor landlord has a freehold estate on the property, she has given a tenant the right to possess the property for a period of time using an instrument called a lease. This lease is a piece of paper and is the personal property of the landlord. Number 30. The federal Fair Housing Law was enacted for the purpose of providing fair housing opportunity for all persons throughout the United States. Explanation. This is the law's basic purpose, to provide all persons in the United States with fair housing opportunities. An agency agreement may be terminated by all of these occurrences except the principal's refusal of an offer to purchase presented in the name of a third person. So I'm going to read the explanation and then I'm going to reread the question because it says an agency agreement. It says the book's instructions are to only read the correct answer, but when there's an except, I feel like I should know the other answers. Okay, the parties may agree to terminate an agency. An agent may renounce it. An agency is terminated by extinction of the subject matter, but a principal's refusal of an offer to purchase does not terminate an agency agreement. Okay, an agency agreement may be terminated by all of these. Destruction by fire of the property that is subject matter of the agency agreement, or renunciation of the agreement by the agent, or mutual termination by both the principal and agent prior to the original termination period. Okay, number 32. The most distinguishable characteristic of personal property is mobility. A personal property has the characteristics of being movable, therefore it has mobility. Being incidental or appurtenant to land and being affixed to land as a permanent part of the land are characteristics of real property. Number 33. Jones is using Smith's swimming pool and suffers an injury. If Jones instituted court action and obtained a judgment against Smith for $2,500, it would be a general lien. A judgment is a general lien when the abstract of judgment is recorded. An appraisal is called upon to appraise a property on which there was a building of no value. The appraiser should appraise for highest and best use and deduct the cost of the demolition. If there is an existing structure on the property, the appraiser will value the land for its highest and best use as if vacant, but must allow a reduction for the cost of the removal of the structure. Liquidity of a financial obligation on an installment basis is let me read that again. Liquidation of a financial obligation on an installment basis is amortization. Amortization is 1. The liquidation of a financial obligation on an installment basis, or 2. Recovery of cost or value over a period of time. Number 36. Mr. Abel obtained a loan to build an apartment building. 1. He planned to charge a higher deposit to single males, and 2. His only source of advertising was to ask his tenants, predominantly white, to refer their friends as prospective tenants. With reference to fair housing laws, Mr. Abel's actions would be correct, and which choice? The answer is only 2. Requiring higher deposits from single males would be unlawful discrimination on the basis of sex and marital status. Limiting Advertising referrals from present tenants would not be in violation of any anti-discrimination law. Not all of the tenants were of any one racial group, and there is no indication that their friends would all be of any one race, color, creed, etc. Number 37. The remedy of unlawful detainer is most commonly used by offended lessors. Explanation. When preceded by a 3-day notice to quit or pay rent, the unlawful detainer is the proper procedure designed by law by which the lessor can have the tenant evicted. Okay. Which is not a specific lien. A judgment lien. A judgment lien is a general lien on all property of the debtor not otherwise exempt by law. A property tax lien, a mechanic's lien, and a blanket mortgage are all specific liens. Number 39. An agent may collect a commission for a negotiated sale after the term of the listing contract expired if the contract contains a protection period clause. A protection clause, also called a safety clause, in a listing agreement binds the seller to the payment of the commission to the broker if the property is sold within a period of so many days after the expiration of the listing to a person with whom the broker negotiated during the listing period. Number 40. A quitclaim deed releases present claim, rights, and title of the grantor. The grantor is the owner of whatever rights are to be conveyed, whether by grant deed or quitclaim deed. Number 41. What will have an impact on the real estate market in years to come? Okay, the answer is all of these. So I kind of want to read the answers. Okay, so the answer, what will have an impact on the real estate market in the years to come? Land use regulation, consumerism, and real estate industry. Explanation. Changes in the real estate market are currently being brought about by growing land regulation, the growth of the philosophy of consumerism, and extended legislative and judicial regulation of the real estate industry. Number 42. What is the first step in the appraisal approach? Define the appraisal problem. Explanation. Before making an appraisal, an appraiser must define the problem to see what is to be done and how it is to be accomplished. Number 43. The amount an appraiser charges for an appraisal is established by the agreement between the appraiser and the client. Explanation. Appraisal fees are set by agreement between the appraiser and the client. Appraisal fees are set by agreement between the appraiser and the client. Oops, I read that. Number 44. What is the best definition of a company dollar with regard to a real estate office? Gross income minus commissions. The company dollar is the money earned by a real estate company and retained by the company after commissions have been paid. From the company dollar, operating expenses will have to be paid. Okay, the gross multiplier is least likely to be used in the appraisal of vacant land. The gross multiplier method involves applying a market-established multiplier to the gross income. Vacant land does not usually produce income. A dual agency in the negotiation of a sale of real property is lawful if both buyer and seller agree. An agent can lawfully act for two principals in negotiation with each other, provided that both principals have knowledge of and consent to the dual agency. In the matter of a broker's commission to be paid by a seller, which statement is true? Actions for the broker's commission must be brought within 4 years of earning the commission. According to the statute of limitations, action for performance of a written contract for a commission must be brought within 4 years of earning the commission. Number 48. Broker Wilson sells a house and a loan for the buyer and is secured through a savings and loan association. Wilson carefully explains all loan costs to the buyer. According to the Real Estate Settlement Procedures Act, RESPA, which statement is true? The lender must provide the buyer with an estimate of a settlement costs within 3 days. Under RESPA, the lender must furnish a copy of special information booklet prescribed by HUD together with a good faith estimate of closing costs to every person from whom the lender receives a written application for a first mortgage loan. The lender shall supply the good faith estimate by delivering or placing it in the mail not later than 3 business days after the application is received. Number 49. To alienate title to real property, an individual conveys title. To alienate means title is conveyed from one owner to another. Alienation is the opposite of acquisition. Okay, number 50. A real estate agent's license will be suspended when the real estate fund pays a judgment creditor of the agent and will not be reinstated until the agent pays back the recovery account with interest. The Real Estate Law B&P Code Section 10475 provides that no brokers or salespersons license suspended under these circumstances can be reinstated until the recovery account has been repaid in full, plus interest at the prevailing legal rate.